Hello and welcome to the Arbitration Conversation. So this is a great webisode. We've actually reached number 55, the 55th Arbitration Conversation. And for this, we have a true expert in the field of dispute system design. Professor Janet Martinez from Stanford. She's the director of the dispute resolution program there at Stanford. She's also been an expert in arbitration, mediation, dispute system design, ODR, for many years. She's a fellow of the National Center for Technology and Dispute Resolution. She's a member and leader in iCoder. Jan, and a good friend of mine. So Jan, thank you so much for taking time to talk about arbitration and how it fits in with dispute system design.
Thank you, Amy. I'm delighted to be here, and I appreciate the warm welcome and the chance for talking with you about things that you and I spend a lot of time teaching and thinking about.
So to that point, you have a fantastic book. I don't know if you would mind showing the cover, Dispute System Design.
Okay.
I will tell everybody, it is fantastic. It'll
Okay.
blow your mind, and I'll tell you why, because it really helps to give you a whole different way of thinking about dispute resolution, right? And when we think about the spectrum of what's out there in terms of ombuds, mediation, arbitration, all these different tools that we talk about, they're not separate things to think about. Instead, we need to think about it within the context of dispute system design. So let me get your thoughts on that, right? I mean, I've mentioned this before, there's been this thought, and I've had students ask me, wait a minute, isn't arbitration just private litigation?
Mhm. And yeah. And I think students understandably are trying to get some way of thinking about all the processes out there. So in our chapter on process building blocks in the book, I think we have 30 some processes. Now, if you had to have 30 processes in your head, in your checklist, that would be not helpful. So what we were trying to do is categorize or I'll step back a moment, is to move from thinking about a single dispute. Whereas if you and I have a business dispute, Amy, and our partnership is falling on the rocks, we might say, well, let's go to call and rule and use online dispute resolution. Or we might say, let's go there and go to court. I'm really mad at Amy. Or I'll go somewhere else. Shall we try to negotiate? Then we teach that. So there are so many choices in trying to get some organization around that. So thinking about how much control do you and I want over the process and the outcome? If we want lots of control, then it's better for us to negotiate. But if we want to give up some of that control to a third party, we might try a mediator who would work with both of us, see if we could come to resolution. Or we might say, we need an expert in our business area. Let's go to arbitration, and the arbitrator will make a decision that is fair and focused on our particular issues. Or we may decide to go to court. Both arbitration and court call for a third party to have control of both the process and the outcome. So it's a kind of a compared to what question. You and I are in a business dispute, so it's compared to probably court. If we were, let's imagine that we're dealing with a consumer situation where the dispute is between a merchant and a consumer, or it could be, as an example I'll use, between Kaiser Permanente Health System and one of their patients. So that's another occasion in which arbitration is often the process of choice. So in terms of system design, I'm trying to think about not just the one dispute you and I are having, but for these kinds of disputes, shall we have a system in place that is easy for you and I to choose? We go to the system headquarters and we say, we want control over the process, but we want something fair and fast. And so thinking about what process choices make sense for us, and then how we can pursue them.
I mean, it's really helpful. I love the other thing about your book and sort of creating a way of approaching kind of these process questions.
Mhm,
What did you find in the course of writing the book? And as you thought, are there certain areas, for example,
mhm,
where arbitration makes more sense
mhm.
when you look at it through the lens of dispute system design and you think
Good.
about the goals and the stakeholders and the control?
Yeah. So I think this is where culture rears its head because in Europe, as we know, consumer protection is a higher priority goal. And so mandatory arbitration is not a process that is allowed in Europe, where it is a process that is allowed in the US. So we have come up with, I think, probably following the idea that arbitration is a contract, an agreement between an employer and employee, a merchant and their consumers, a hospital and its patients. But it's an agreement that really isn't balanced, right? And so the merchant or the employer or the hospital is in a position of more power and leverage. And they often say, we want a dispute system that is going to be pretty uh, inexpensive, not cost us much. I don't think they're caring so much about the other side, but cost is definitely an issue. Cost in money and cost in whether you have to have a lawyer, cost in to the other both parties. And so thinking about what kind of process do we want to put in place, and is there a way with the temptation that the hospital, the employer, and the merchant all say, we want mandatory arbitration because it can be quick, predictable, we can control the process, and therefore keep the costs down. So, as an employee or a patient or a consumer, we look at this and say, what? We have no choice. How does that feel fair? And so, really, is there a way to make arbitration experience more fair, but also cost effective for both parties? And so, one of the examples that I use in teaching is the Kaiser Permanente case, in which Kaiser's mandatory arbitration system was deemed to be unfair. Times and services and all that sort of thing were not happening as committed. And so the Kaiser had to step back and say, what can we do? We really want to use this mandatory arbitration. We want to use expert deciders. What can we do to make it more fair and credible as a process to the public? And so they went through a process of using independent appraisers, look at the cases, review the panels of arbitrators, and review the outcomes and improve their system. And Alan Morrison, who was Solicitor General of the US, wrote an article on this a few years ago. And he said, really, is this arbitration as fair as they say it is? And so he looked through a more careful data analysis of the cases, the arbitrators, the decisions, the transparency of the process, and the outcomes. And he found, taken as a whole, that parties were doing as well at probably a lower cost and less time through the mandatory arbitration system than they would have done if they had gone to court. So as a researcher, you clearly need some data to measure cases of a similar profile and going through the two processes and do the comparison. So he was a very probing research to examine what the outcome was of the process and was it what Kaiser committed it to be. And so that was an example of compared to what. But I think for parties wanting to put mandatory arbitration into place, whether they are going to give an alternative to the users like mediation, Actually, Kaiser has included mediation since as one of the optional processes, which makes it more of a system. They also have probed on preventing disputes before they get ripe, and seeing if something in the process choice can reduce the number of cases that really go to full-on conflict. So I think that's another angle to the system approach, is looking at, are there diagnostic, more data and information processes that would be available so that we could stop the dispute in its tracks before it really becomes unpleasant for both parties.
Right. Well, and definitely I like this compared to what. I think it's such an important question that often we forget about, right? And I think it makes sense also when you're thinking about areas where you do need particular expertise. For example, oil and gas or different industries where maybe the arbitrator would have special expertise.
Yes, right.
How would that fit into dispute system design? What question would we be asking?
So let's imagine, from what you were saying, that we're looking at a commercial situation, and I've interviewed PD Villarreal, who's head of global litigation for GlaxoSmithKline. And so he's given a lot of thought to what kind of system does a company put in place, and what are the steps they would go through. And he found that it would be really valuable to get upstream before the dispute is ready to go to court, to go upstream. And when there's first some kind of conflict between a company and its customers or its suppliers or employees for that matter, as soon as there's an issue, that they focus on intervening at an early point. So they invested a lot of energy and money into training all their executives around the world in the basics of negotiation, thinking that if they knew early on how to engage with the other side and problem solve, as you teach in your course, that would cut off some of the supplies of conflicts that were going to go to any of the other processes. They inserted an option for mediation. And in many cases, they do go to court for one or two cases to test out, if it's a product liability case, how are these cases sorting out if we go to court? They may decide to go with an expert arbitrator and say, all of these kinds of cases, we are going to send to a panel of arbitrators. Another place where arbitration comes up in the commercial context, there was a case a few years ago of racial discrimination between a Fortune 500 company and its employees. And it was a class action. There was money set aside, and so they needed to design a process for dealing with all the claimants in the class. And so they gave them choices. They gave a choice in saying, you can submit a survey that identifies the number of years you worked for the company, the position you were in. And using data alone, then it was decided what the remedy would be. But if you wanted an opportunity to tell your story, what your experience was like as an employee and how that discrimination was devastating to your career and your sense of service and competence. And so that was a different process. And there was a master, Lynn Cohen, who was the head of the dispute resolution design for that case. And she put together something that was a quasi mediation arbitration. And they put together the processes that would fit these particular employees, this particular cause of action. And so in that case, the arbitrators had a protocol to refer to for determining the damages. And
Wow.
Yeah. And so
That's
I think
interesting.
it was interesting as it combined the expertise of an arbitrator with an option to tell your story and
Mhm.
have voice, and which was a really important part of the case experience.
That's so interesting, and it makes
Uh-huh.
sense. And it's these times when you see how having a really sound dispute system design and thinking of it from that standpoint can really be helpful for both dispute prevention as well
Yeah,
as dispute resolution and really problem solving overall.
yeah,
It's
yeah.
such a contribution to the field, and your book and your work is such a contribution to all of us who teach
Okay.
dispute resolution. So thank you, from all of us who teach
Well,
classes in the area. It's really good stuff. And thank you for taking this time to talk with us today.
thank you for inviting me. Thank you, Amy, and my best to all of you who watch this.